Can you hear me?
We
Okay,
can. Thank you. Good morning.
great.
Thank you for being here.
Sekasine, good morning, Chair Escobar, board members and staff. My name is Melissa Tayaba. I am the vice chair for Shingle Springs Band of Miwok Indians, and I am also the director of traditional ecological knowledge. And so first, I just wanted to welcome all of you here today to my ancestral homelands, the homelands of the Nisenan Pewanan, which of course is the first peoples of this region. My people come from these rivers. My grandmother actually was just born at our village very close to here with the village of Pashune, which is the confluence of the American and the Sacramento rivers. Other matriarchs were born upriver at the confluence of the Feather and Sacramento River also. And so with that being said, what happens to those rivers is very, very important to us. But most importantly, it's a responsibility that we have to protect those spaces. So when we talk about protecting the health of our rivers and watersheds, we are simultaneously talking about protecting and preserving our culture, our indigenous lifeways, and our identity. Culture is ecology, ecology is culture. It is all connected. I want to thank you for providing the time and space today to hear from California tribes on the Bay Delta Plan Draft Staff Report. However, more outreach to tribes, more tribal engagement, more opportunities for dialogue and exchange of information is required. In an effort to problem solve, we have met with your staff and have even spoken with some of you about the importance of tribal engagement and how you can improve your processes. We've offered suggestions and highlighted best practices such as going beyond an outdated tribal contact email and mailing lists, making calls to tribal offices, conducting follow-up, getting to know tribes within the watershed, even asking neighboring tribes about who appropriate contacts might be that you aren't aware of. And more importantly, meeting tribes where we are in our preferred method of engagement, whether it's virtual or in person. You must find ways to be responsive to and inclusive of tribes. The inclusion of tribal voices in any planning process where outcomes and impacts can be detrimental to us is necessary if you are to uphold your obligations to ensure adequate water quality for all California communities. It is particularly important that tribes are engaged in this process and consulted on the various elements of the proposals included in the draft staff report that would impact tribes, especially when those impacts are potentially and fundamentally inequitable. There has not been enough engagement and consultation with tribes throughout the Bay Delta watershed, one virtual tribal only meeting and one in-person tribal meeting for our watershed that spans roughly half the state is severely inefficient. In some cases, tribes have been intentionally excluded, such as through the voluntary agreement process. We are disappointed and concerned that the draft staff report includes the voluntary agreements at all. We do not believe consideration should be given to any proposed approach to managing our waterways that, one, exclude tribes in consideration for our tribal cultural resources and uses, lacks an implementation plan for tribes to evaluate, three, relies on an 8-year experiment with questionable flow regimes based on pseudoscience, controlled by water agencies and irrigation districts with no adequate oversight. 4, lacks proper in-stream flows to protect the environment and uses narrative as a replacement for quantifiable water quality and flow standards. And 5, that further jeopardize our salmon and native fish populations already on the verge of extinction. There is no justice for tribes without the recovery of our fish species. We oppose the voluntary agreements fundamentally. They are exclusionary and inequitable in nature, and we urge the board to reject the staff recommendation that they be considered as a viable proposal. We also urge you to revisit your racial equity resolution and apply a racial equity lens to your decision-making process going forward. There is no way to include tribal perspectives without having tribes present to speak for ourselves. There's no other way to incorporate our indigenous knowledge, tribal values, or even begin to understand the protections we need for our tribal beneficial uses without collaborating with us directly, genuinely, and intentionally. In closing, I'd like to add that we appreciate the draft staff report's recommendation to include the incorporation of tech and indigenous knowledge into the Bay Delta Plan update. However, further discussion, engagement, and consultation with tribes is necessary to ensure that incorporation of our knowledge is not an exercise of extraction, misuse, or commodification of our knowledge. There must be protections in place in a way that honors and holds sacred what we choose to share. That's all. Thank you.
Thank you, Vice Chair, and completely commit myself to that genuine continued engagement and just appreciate your time and comments here with us. And I know we'll continue to have further discussion. So just thank you so much for that, your voice here. Gary, good morning.
Good morning.
Sorry, you'll need to turn on your mic there for a moment. Thank you.
Boy, I could talk loud. Good morning, Chair Civillo. Good morning, Board. Thank you for the opportunity to be here. I will inform you that many of us asked permission to be here from the people out in front because we support unions and we support what they're doing. So we are here at their permission, as well as you being inviting us. So I'm going to talk about tribal water rights here, tribal engagement, section 11, covers a little bit of, or you kind of pass over the Winters Doctrine and a couple of other things about federally reserved rights, federal tribal rights and things like that. So I have some presentations. They were up. The slides were up when Vice Chair was doing. Yeah, there we go. So if you go to the first slide, it's tribal water rights. You know, where is our water? And you're going to hear why that's important and what tribal water rights are important into everything you're going to hear from the rest of the folks on this panel, the next panel, and the panel farther on down the road. Next one, please. In California, there's about 100, 109, 110 or more federally recognized tribes. There's more than 80 tribes that are not federally recognized, but are recognized by the state somehow. And the one thing that you haven't addressed is there are over 300 individual Native American allotments located both on reservations and in public domain, all qualify for quantification. And we're going to be talking about quantification in a minute. Next slide, please. I'm going to go fast because I want to make sure my nephew here has a chance. And I can't read that, so I'm going to read the slide here. So federally reserved water rights on Indian reservations are governed by the Winters Doctrine, which is mentioned in your section 11 here of the water plan. That's why I think I'm able to address it, which has evolved over more than a century in federal courts and since 1955 in state courts as well. Two landmark U.S. Supreme Court cases, Winters versus U.S. and U.S. versus Rio Grande Dam Irrigation Company, established several key principles. Federally reserved lands have a right to use sufficient water to fulfill the primary purpose of the land of the reservation. And two, this is key, these water rights cannot be destroyed by state water law or by water users acting in accordance with state water law. That's why we're talking about some water rights here as we get into it. Evaluation of tribes' water rights requires a determination of two factors: the date on which the land became federally reserved, the priority date, and the amount of water needed to fulfill the primary purpose for which the land was federally reserved. Federally reserved water rights have priority over all other water rights dating from the time when the reservation was first created and cannot be appropriated by the state. In California, there are no treaty tribes Yeah, next slide.
Next slide, please.
In 1851 to 1852, federal agents negotiated 18 treaties with California tribes. This is history, you all know about it. These treaties were never ratified because the state of California legislative representatives talked to the U.S. Senate and said, don't ratify those, we want the resources. So the U.S. Senate hid the treaties away, weren't ratified for over 50 years. They didn't surface until 1908. And in 1908, in 1907, the year before that, they had passed I forget what the name of the act is, but it restricted the president from making any treaties with tribes anymore. So they surfaced after they couldn't be ratified in the first place. So that was kind of neat, don't you think? Congress in 1851 also passed the Land Claims Act, providing that all lands in California would pass into public domain unless claimed within 2 years. They didn't tell the tribes this because the tribes thought that they had signed treaties. They were going to get reservations. We were going to have our own property, our own land to live on. And so we didn't go and claim land because we thought we had it already. And guess what? That kind of took us away there. Under pressure from California statesmen, I already talked about all that. It is important to understand, though, that the priority date of some cases is actually earlier than the creation of a reservation because some reservations were created. Then you had the Termination Act, which came in, got rid of the termination reservations, and then they did the other act, which allowed them to go Self-Determination Act, which allowed them to reform as a reservation. But the original date of that reservation, or the original date of the military school or the boarding school, the military facility, boarding school, fort, whatever, where the tribe is located, is considered the priority date. So even though, say, in 1958, a tribe was reformed, but if they were formed on land that had prior federal designation, that becomes the priority date. So it rolls back to the 1800s, late 1800s, 1850s. Let me get over here. It is also important to understand that there is no requirement that the Indian people of a reservation actually use the water from the priority date. Unlike water rights of the state of California, federal reserved rights do not expire if water is not used. As a result, Indian tribes may decide to use their water rights later than other users and still have a senior right to sufficient water for the purposes of their reservation. Only landowners who have had made continuous beneficial use of water since before the priority date will have a right to senior of the tribe. So, and that's very few. And under SB 389 now, you can figure out who those people might or might not be. I just thought I'd throw that out there. Determining water rights. Next slide, please. In recognition of the importance of finality of water adjudications, the U.S. Supreme Court has found that tribal water rights must be quantified for both present and future uses. The method most commonly used is the practicably irrigable acreage, or PIA method. The PIA method quantifies the amount of water needed to irrigate arable lands on the reservation. The weight of authority holds that federal reserve rights include both groundwater and surface water. That's important to know. The Federal McCarran Amendment provides for a limited waiver of sovereign immunity so that the United States, as a trustee of tribal resources, can come in and talk to you folks or mediate and whatever and determine tribal federal reserved water rights. Together, a tribe's priority date and primary purpose quantity must be used to determine the tribe's, I got 6 minutes, okay. To determine the tribe's water rights. This mechanism also allows for the permanently quantified tribal water rights and to allow for informed planning by you, businesses, and everybody else, right water allocations. Here's the key one that we haven't talked about and we just alluded to, is that allotments made to individual Indian persons can be divided into two categories. First, lands on Indian reservations, which were allotted to individual members of federally recognized tribes under the General Allotment Act of 1887, that's the Dawes Act. Second, lands on public domain, which were allotted to individual members of both federally and non-federally recognized tribes. Be aware of that because My family has allotments. Colleen's family has allotments. There are many tribes, individual people up and down the state that have federal allotments that that are still in effect. They're still in the public domain. We haven't sold them off. One of Congress's intentions in passing the Dawes Act was to encourage Indian persons to adopt an agricultural lifestyle. Both the Dawes Act and U.S. Supreme Court have recognized that on-reservation allotments are entitled to a proportional share of a tribe's federally reserved water rights. Thus, individual allotments located on a reservation must be included in total acreage when calculating a tribe's PIA. Public domain allotments located off of an Indian reservation are subject to the same principles as Dawes Act allotments in other federally reserved lands with respect to water rights. That is, water rights attached to a public domain allotment are determined by application of the priority date and the primary purpose as discussed above. So all those allotments that are still out there in the public domain, our chief's family allotment, my family's allotments, and several other families' allotments still qualify for federally reserved water rights. And they haven't been accounted for or quantified because the state of California has never accounted for or quantified those water rights. I'm not going to, next slide, please, but I'm going to talk about, I'm not going to go to that conclusion yet because I have a couple other things to say. These are from my attorney, our attorney from Restore the Delta. And she relays that the board needs to undertake a more robust program to quantify Federal Reserve water rights and ensure that water is not available for appropriation. That's an important statement there because now you're looking at updating the Bay Delta plan. That's going to include flows, allocations, water quality, all those kind of things. And when you take into consideration those things and you do your metrics, be sure that you do not include or appropriate Federal Reserve water rights. And in order to not include Federal Reserve water rights, you have to quantify them. So you've got, till next year when you put the new thing out to quantify some of those rights. Board will likewise need to ensure that implementation of the Bay Delta Plan does not impinge on Federal Reserve rights, including unquantified water rights. That's from the attorney. The US EPA is in the process of finalizing a rule, by the way, that will formalize and clarify already existing requirements that state agencies, including the board, ensure in setting or amending water quality standards, that those standards protect tribal reserved rights. The board does not appear to have undertaken this analysis for the Bay Delta Plan update, and that's why we're bringing it to your attention. For instance, it is not considered whether the continued reliance on water from the Trinity River, it's got snuck in here, for the Bay Delta flows will impede exercise of tribal reserve rights held by tribes on the Trinity and Klamath. So that's a really good example of how that could impinge on tribal rights. The voluntary agreements turn water quality standard setting and attainment over to water agencies and irrigation districts, ignoring the existence of Indian tribes, including those who hold Federal Reserve rights, as well as tribes' millennial-long role in water stewardship. The VAs thereby act as another instance of the erasure of Indian tribes from water governance. Their 8-year experiment and the water agencies and them putting forth what they think is going to be the best thing for the meaning of life and everything is excluding tribes, tribal tech, tribal TBUs, tribal water rights, Federal Reserve water rights, and excluding all of those things. And they're actually going to be taking control over the management of that and the decision-making during those voluntary agreements. And that's another reason why you should oppose them. The history of broken treaty promises and the state's direct role in preventing ratification of the treaties makes it all the more important that the board ensure that flows are adequate to protect cultural, spiritual, and economic practices for all tribes. By, for instance, designating the TBUs in the Bay Delta Plan, and that it meaningfully engage tribes as partners in this process. In conclusion, California Day Delta Plan update does not account for tribal water rights, which have not been quantified. The exact count of tribes whose water rights have been accurately quantified is unclear, but what is clear is that the tally is far below the total number of federally recognized tribes in the state. Furthermore, there is no evidence to suggest that the water rights of any public domain allotment have been accurately quantified and incorporated into water allocations. Not properly accounting for reserved tribal water rights limits the ability of the State Water Resources Control Board, other public entities, businesses, tribal governments, and individual landowners to formulate equitable, reliable, long-term water usage plans. Tribal water rights must be addressed and quantified. Thank you.
Thank you, Gary. Appreciate your comments. Ivan.
Good morning. My name is Ivan Sinok. I am the TIPO and Cultural Resources Director for Buena Vista Rancheria of Miwok Indians, whose ancestral homeland is along the McCallamy Rivers, as well as the lower San Joaquin Rivers, as well as the central and southern Delta regions. I'm glad to be here and thank you for the opportunity. I will be building off of what the other two tribal representatives have spoken about today. In particularly, as discussed by my colleagues and fellow representatives here, the Bay Delta Plan needs to continue the discussion of tribal engagement. Tribal engagement written into the staff report is minimal at best. Our panel are representatives from 3 tribal governments, each with their own sovereignty and responsibilities to their people. I'm a representative of a sovereign nation. I am responsible to its members and to the government to which gives me the authority to speak. Tribal sovereignty means that each individual tribe has an inherent right and authority to govern themselves. Tribal sovereignty is cited in the United States Constitution, Article 1, Section 8, that determines tribes are separate from the federal government and separate from state governments. Each tribe holds its own sovereignty and authority, thus proper engagements with tribes means to seek an amicable relationship based on the respect of their status, meaningful discussions, and solutions, as well as addressing the tribal concerns. The Bay Delta Plan will affect over 100 tribes in the state of California. That's a very, very big number. California is a unique place on the West Coast. As cited by my 2 fellow representatives here, they are one of the most packed states with tribal nations, both federally recognized, non-federally recognized, as well as individual allotments. In the staff report, it is stated that you reached out to over 90 tribes. However, only 6 engaged through the process. True tribal engagement requires more. The laws that require consultation are the bare minimum requirements for your agency. We all know CEQA, we all know AB 52, and the word soup, alphabet soup that we all have to deal with on a daily basis. But these are the minimum requirements set for the board and for the state. To engage with the government is more than to send one email, one physical letter, and one phone call. Your own policies indicate that you will communicate and engage, consider potential impacts, and recognize and respect the tribal cultural resources of California Native American tribes, regardless of where they are located or how they are defined. In the absence of legal consultation requirements, the best practice is to consult with tribes out of respect for their status as sovereign governments and based on their unique tribal interests that may be affected by your proposed action, policy, or set of implementation actions. Again, a single phone call, letter, or email does not meet the requirement for a good faith effort to engage in government to government. The board must consider enhancing the engagement with tribes and the concerns for safe, protected, and properly managed waters held by each tribe. One of our major concerns, and one of the reasons I am speaking with you today, is the definitions and considerations of tribal cultural resources. Tribal cultural resources are defined in California State Law AB 52 as sites, features, places, cultural landscapes, and objects with cultural value to California Native Americans. That is a baseline. And that is not the definition that Buena Vista holds. It is not the definition almost any tribe holds. Those are more. Buena Vista defines tribal cultural resources, I'm going to call them TCRs, and that way I'm not repeating the same thing, as spiritual and cultural landscapes, sacred places and objects, animals, plants, and water. Habitats, sites, features, and places with spiritual, cultural, and historic value to Buena Vista Rancheria's past, present, and future generations. Water is a tribal cultural resource. Tribal cultural resources are often non-renewable and irreplaceable, and they can be destroyed if they are mismanaged and not properly cared for, and not just mitigated for. As a sovereign nation, you must respect and acknowledge our definition of tribal cultural resources. The Bay Delta is a tribal cultural landscape to Buena Vista Rancheria and the 100 other tribes that exist in this place since time immemorial. You guys actually happen to cite Buena Vista's Rancheria's water program coordinator in your definitions and documentations of TEK, and you cited her incorrectly. You said that McCollum is Miwok for people, but McCollum actually has a more intimate name to the river and the places and the spirits that inhabit that place. McCollum means people of the fishnet. It is the name of a village site along that ancestral river. Next time you guys engage in documenting TEK, please do it correctly, which is engaging with tribes, having a discussion. And if you seek to quote our members, if you seek to quote our government staff, please reach out appropriately. That should have been a phone call to me before even writing it and placing it into the staff report. I hope to hold you to a higher standard so that we can have an amicable relationship, so that we can manage waters appropriately and we can manage all resources appropriately. This touches on the topic of traditional ecological knowledge, or TEK, and it's interweaving into your policies as referenced in the staff report as an ongoing effort to be documented. This is somewhat problematic, and I would argue highly problematic. TEK and the larger indigenous knowledge is part of lifeways. It's part of someone's life. It's part of someone's family knowledge. It's part of a place's knowledge. You cannot download and document someone's life, perspective, culture, religion, and simple existence and squirrel it away. That is not how you properly implement TEK. TEK would be implementing by having a tribal seat on this board to bring a tribal perspective when you guys are ruling and making decision. It would also have tribal peoples discussing with your staff, working in tandem with scientists and other knowledge holders. TEK does not espouse itself to be the one and only knowledge. It is one of many areas that humans hold knowledge. And TEK requires the subject matter experts. And the only subject matter experts that exist for TEK are the tribes. The only subject matter experts that exist for tribal cultural resources are the tribes. This is Buena Vista's view, and we share it with the other two representatives here at the table, as well as many other tribes in the state of California whose resources you are determining. Lost my place. I have two main considerations for you for TEK. First, TEK will only be shared when there is a continual engagement through discussions, meetings, consultations, technical meetings, and tribal representatives in decision-making places. That is the only true way to implement TEK. TEK cannot be extracted by requesting information in letters or phone calls or simply asking for input. TEK is learned by working with, listening to tribal concerns, and implementing tribal ideas in your management. These kinds of requirements should be set forth in this plan. Second, TEK must be respected. It is not something to be extracted from tribal communities. It is not supposed to be a continuation of ethnocide and genocide that has been committed throughout California. If you seek to take a people's knowledge and use it for your own, that is extraction. And that is not what the government, the governor, or current policies dictate for. Acknowledge the historic removal of tribes from decision-making places of power. Open those decision-making, open the people who write these reports up to tribes and have tribal representatives and people who hold tribal perspectives there. That is how you implement TEK. I will give you a snippet of TEK, and you will hear from other experts in the fields on the later panels talking about TEK and the importance of TBUs. Buena Vista Rancheria asserts that the delta in the tribal sense, the watersheds regions, the different areas, all of the tributaries and all of the waters that flow, is a tribal cultural landscape made up of numerous and almost infinite water, native plants, and animals and locations specific to each tribe as a tribal cultural resources. I see I'm running out of time here, but in order to move quicker, Buena Vista Rancheria supports what the other representatives here has said and share in the idea that the VAs should not be pushed forward or voted on. It has excluded tribal voices until this year. It has excluded tribal representation. It has excluded tribal thoughts. It has disrespected the sovereignty of the 100 tribes that this plan will oversee. And on that basis alone, the VA should not be voted on and implemented. Beyond that, we request that the public funds have been spent by state and federal agencies on these VAs. The public must be brought in as well. Tribes acknowledge that we are not the only people who live on this landscape and who live in this world. These are shared resources that we seek to have better relations, better management, and truly an amicable relationship with everybody. These resources need to be managed properly with everyone at the table, and that is a TEK concept. Thank you for your time, and I hope to be speaking with you further.
Thank you very much for that, Ivan. And I'll hear the members of the tribes and importantly, want to affirm that that's a value of this board as well. Very public, open process that is meant to bring everyone to a common table and try to figure out how we all equitably together manage very, I know, difficult circumstances oftentimes in our watersheds and very difficult histories. So I just really appreciate your voices and your work today. Thank you. Yes, Board Member Firestone.
Thanks, and thank you again for coming and for all the work and dialogue that we've had so far and that we have yet to come. I really, really appreciate all the perspectives that you brought here today and that we're continuing to learn from. Really look forward to digging in more on these concepts. One thing I wanted to just ask if you wanted to speak to more were examples of models of co-management or TEK consistency with TEK in terms of governance and co-management models out there, either for especially just taking into account the need for adaptive management and ongoing decision-making throughout implementation of any plan. Are there examples or structures that exist in other places that you all have participated in that would be important to lift up for us to look at that are examples of that kind of co-management and respect? Thanks.
Well, I'll give you a recent example. The Winnemem-Wintu tribe signed a co-management agreement with NOAA Fisheries and California Department of Fish and Wildlife, or fishing, whatever, if that's how it is, to reintroduce salmon in the McCloud River. It's been 2 years now. The first year of the salmon introduction, the eyed eggs was put into incubators on the river in the Department of Fish and Wildlife incubators only, with the water coming through. Those fish did survive. There was a sediment problem, But this year, the addition of 40,000 new eggs in there, half was put into a system developed by Department of Fish and Wildlife. The other half was put into a system developed by the Winnemem Wintu tribe based on tribal ecological knowledge. And the way that the eggs were laid in, the layeredness, the way the water came across and all that, the 20,000 salmon eggs that were in the Department of Fish and Wildlife's incubators died. The 20,000 eggs that were in the Winnemem Wintu's technical ecological knowledge incubators lived, and they've been put down into the river. And so there's an example of working together with co-management. Now, Department of Fish and Wildlife has learned from us. We've learned from them. There's an example.
Thank you so much.
And thank you, board member, and thank you for that, Gary. I think one of the fundamental tensions certainly is that we have a very Western regulatory structure that we've built up with Port of Cologne, and it doesn't easily translate over to tribal ecological knowledge. But I'm confident we can do that translating. We can, through a lot more discussion, I know, figure out how we do that bridge. But just to acknowledge that that's what we're dealing with on this side, and it's our job to translate how best we bridge over to you on the incredible work I know that continues to go on to incorporate meaningfully tribal ecological knowledge. So TEK, appreciate it. Yeah, thanks. Thanks, Gary. Thanks again. And did you want to say anything further, Ivan?
I hinted to this in my presentation, and I'm ad-libbing at this point. Laws and federal regulations and state regulations are good. They can always be improved, as we all know, and regulations are regulations and the headache that they are. I like to consider them, because I span the gamut for tribal cultural resource laws. Consider them as baselines. You can always do better. You can always do better in policies. You can always do better in procedures. The board has their own tribal consultation policy. The regional boards have their own consultation policy. I believe almost every agency, commission, and board in the state of California has their own consultation policy. And that is where the flexibility comes from. And imagining laws as baselines, and the goal is to do better than the baseline, is a good way to start.
Here. I completely agree. The standard setting that we do is the floor often and what we're not actually able to achieve. So thank you so much. Let's go ahead and